You're our presenter, and then when you're through, you come up here and sit with us. You're on the
I know. This is kind of oddball thing. Yeah. Yeah.
You came in, you started with so we had Barnes.
She's right here, right here.
She's right here.
I didn't know she had a order. I don't know already.
I think I grabbed that, or maybe she grabbed that for them. But yeah, I grabbed.
Morning, everyone. If we'll take our seats. Just about, got about, well, I didn't expect y'all to get quiet that fast. All right, so we have about a minute or two before we get started. And I'm going to see if I can reel in a committee member who's trying to get out of the door. So, Corbett, if you'll move down a little bit. Yeah, no. He's going to be the first out if it gets hot in here. So.
Is this close enough?
Yeah. You just have to clear the way for me. Good morning, everyone, and we're going to begin our meeting in just a second. We start. We've been having a lot of questions, and we too are learning our way as we do the study committee. This is not David Hartman, so who has always been with our Natural Resources Committee, but this is a larger issue for the whole General Assembly. That's what the study committee is about. So, Brock, take a brief second to introduce yourself before I call the meeting to order.
I never had to do this.
Where are you? He can't talk because I can't figure it out. Okay, there we go.
Yeah.
All right, now I recognize. Okay.
Good morning, everybody. My name is Brock Perry. I work with the House Budget and Research Office as an attorney analyst, and my role is to not talk but to listen and take notes, so I'll do that.
And I will point my finger to him if y'all have any hard questions. So, so I'm going to call the meeting to order. If you'll just push your button for me. Okay, thank you. I'm calling the meeting to order, and we generally open it with a prayer. Thank you. Mr. Representative Corbett.
Thank you, Madam Chair. Y'all bow with me. Dear Lord, we just come before you today, Lord, just weak and humble, Jesus, for no how. Lord, just want to thank you for this day. Just thank you for many blessings you bestow upon us each and every day. Lord, just want to thank you for this great state of Georgia we get to call home. Lord, we just want to thank you for the abundance of natural resources that we have here to enjoy, Lord. We pray that we get to enjoy them, preserve them, and pass them on for future generations. Lord, we just pray now that you just lead, guide, and direct us in everything that we do and say here today to be pleasing in thy sight. And all things we ask in Jesus' name. Amen.
Amen. That kind of covered all the bases, so thank you. So before we get too far into this, I'm going to ask our committee members to introduce ourselves. So if we'll start with you, if you'll push your button for me, I can recognize you.
Thank you, Madam Chair. State Representative John Corbett, District 174, 6 counties, right on the Florida line, Lowndes, Eccles, Clinch, Ware, Charlton, and Brantley counties. This is my 10th year in the legislature. I've been on the Natural Resources for 10 years. Enjoy this committee. Enjoy working with Madam Chair. She runs a great committee, and look forward to serving on this committee, and hopefully we can come up with some solutions.
Thank you. Push your button. Okay.
Thank you, Madam Chair. Al Williams, District 168, where the water tastes like cherry wine.
Oh, no.
I've only got one county, that's Liberty County, the fastest and the greatest.
And flooded right now, correct?
Yeah, but we were ready. Everybody's back in and waiting.
Great.
All right, I'm Representative Stan Gunter from the 8th District, which borders North Carolina. I have Towns, Union, and most of White County. This is my 4th year in the legislature, and I look forward to these hearings and what we come out with.
Thank you, Madam Chair. I'm Johnny Chastain. I'm in the 7th District up in Blue Ridge. I have Fannin County, Gilmer County, the western slither part of Dawson County, starting my 2nd term, and glad to be here today. Thank you.
And we have one member who is listening in but can't be here today because of a conflict. That's Representative James Burchett. And we have another member of the committee who's having to work today, and he will introduce himself when he talks to us about water law. Before we get started, I want to take maybe about 5 minutes to explain to you that this truly is a study committee. We don't have any legislation in front of us. I don't think we have positions necessarily, and we're here to listen. And I want you to understand that half of our General Assembly is a turnover. Most of our members have less than 4 years or maybe 6 years of knowledge serving on the General Assembly. And it takes a while to get the rhythm and to understand a lot of the issues, especially the ones that are setting our pace now that happened a long time ago. So the purpose of this meeting is more of a tutorial. Yes, I was an educator at one point. Also ran a printing company, so I know about deadlines. But anyway, we are not moving at a fast pace, and I don't think our committee members have an agenda. But I think for a lot of us, we don't have the historic knowledge of what we need to have as we try and make our way through these complex issues. And I'm going to, I hope, remove some pressure from some of our newer members as to what it was like for me when I was brand new at the General Assembly. Newt Gingrich was the Speaker of the House, U.S. government. We were in a tri-state water wars. We were getting ready to sign a water compact that was just enormously needed and desired and popular with all of us. And we did sign it, but we kind of left out one word in that document, which was allocation, which was what the argument was about. But anyway, it was a step forward. And here I come as a new legislator, and we had such horrible problems with pollution of all of our rivers, not just one river. And I live south of Atlanta, Noonan, Georgia, and I came up, and I was really good at this, and I could tell everybody, you know, we've got problems with the Chattahoochee where I live. And I said, look, I don't even have to show it to you. Just take a deep breath. You can smell it, because we were the flush toilet for Atlanta. And the rest of the state had that attitude towards Atlanta as well, and they were not doing what they needed to do. So there were all sorts of solutions floating around out there. And one of them was to increase the buffers. And so there was a big effort to increase the buffers north of Atlanta. Also, to set the picture here, we didn't have cell phones. And it was like the Wild West. If you got out in the hallway as a legislator and you were just trying to go to the restroom, because there weren't many restrooms for women back then. So anyway, you couldn't get there. So you were just always surrounded by a lot of opinions. And we would gather as legislators at the depot. And so one night at the depot, of all persons, Speaker Murphy said, well, how's it going? Now, keep in mind, as a female, I was a female Republican, which was an anomaly. I was not a Democrat, which was a big, bad black check mark against me. And so Al was the only one who talked to me, but it took him a few years to get up there. But anyway, here I am hearing from lobbyists in the hallway. And really, you could not, we needed Moses, but you couldn't part the hallway to get anywhere. And so everywhere I went, somebody was telling me what to do about increasing the buffers on these rivers. And so I asked Speaker, he said, well, how's it going? I said, well, Mr. Speaker, if you want to take time talking to me, which lobbyists do I talk to find out about the issue I need to be on? Because that's all I was hearing from. And he laughed at me so hard, I thought, what in the world have I said to him? He said, back then, these were some of the, he said, Missy, I've been up here a long time, and a lot of these lobbyists are my good friends. He said, but I wouldn't listen to a blank word they say to me. And I said, what? And I said, well, how do you figure things out? And he said, well, the last I checked, there are 179 other people that you work with in the General Assembly in the House. And he said, you need to go to the person impacted by this debate. And the person impacted was a former member of White County. And so I said, Mr. Speaker, he is not going to talk to me. I said, I walk by and I just get this, like, all right, you're there. You walk by me, motion from him. He's never said a word. Oh, so anyway, I do as suggested, and it shows you how savvy Speaker Murphy was back then. I get into the representative's office, and all around his office are maps of elevations, topography of the area around where he lives. And so he didn't know how to talk to me. He said, ma'am, I'm just a plain-spoken mountain man. I'm doing this because Speaker Murphy asked me to. And he said, what do you need to know? And I said, well, that's why I'm here. I don't have the knowledge I think I need to make a decision. And he said, ma'am, if he didn't say I'm a plain-spoken mountain man, he didn't say it enough. I'm not repeating it enough. So anyway, he said, well, see these maps. And I looked, y'all, there were 5 maps plastered on the walls. And so I looked at the maps, and he said, you see those little circles everywhere and the misshaped sort? And I said, yes, sir. I had studied geography. I said, those are elevation marks. And he said, yes, He said, see this first mark by this trout stream? I said, yes, sir. He said, I go to the next level and I cannot build on my property. You have taken away my property. Back then, it was called inverse condemnation when you tried to do a buffer. And so I said, all right, I think I'm getting what you're saying. And he said, we're in the mountains. 25 feet is huge, and to increase that, you have removed my ability to use my property. I said, oh. He said, ma'am, I'm just a plain-spoken mountain man, and I don't know how else to tell you, but while I can pee a stream better than what them folks in Atlanta's calling a stream, a mountain stream. And I went, oh. And I said, oh, okay, I get it. Thank you. And I left, but my message to all of us, first of all, this isn't going to be a pissing contest. We're here to learn. The second lesson is that we appreciate the input we get with folks in a way to describe it, have a vested interest in an outcome. And it's our job to listen to the people we represent, the people of the state of Georgia, the experts we have in the field, and that will be the guiding principle of this. So I have no agenda. I hope that this is the tutorial for all of us, for me, for the rest of us, as we work our way through this issue. And again, we are not charged to come up with the conclusion. And actually, as a committee, if it is in our interest to explore a topic that is not specifically listed, we can go there. We do have our first presenter who is also on this committee, and he has extensive knowledge of water history, and we need that knowledge before we go any further into how we discuss and talk about our debates. But I don't see this as a bad problem that we're tiptoeing around. It's actually a wonderfully good problem, because when I was first elected, we were all limited in our withdrawals from any river in the state. We were in a lawsuit with 2 other states. We were very limited there. And as we went along, it took into 2008, I was first serving in 1997, when we came up with ways to approach the situation. And then, the good Lord sent us a drought. And so we went from maybe solving one problem to trying to figure out how to solve another problem. So when we do have one issue that is in court that we will not, as a committee, go too much. We will be advised if we're stepping in an area we shouldn't do. But as we go along, I hope we learn what we need to know. But when we look at what's going on in the rest of the country and we look at our state, our problem is that we have an abundance of natural resources. The other thing is, we never looked at until I think it was Governor Perdue, and he had a problem called Go Fish. And that was to recognize that fishing and use of our rivers is not only available to people, but it is also part of our economy. So there's an interest there in finding a balance. We are not fighting over who's going to help supply water to a neighboring county because the drought has limited their water resources. They're down to not having anything to draw from. We're to a problem of dealing with abundance, and we wish to share our resources in a way that is beneficial, if possible, to all. So keep that in mind as we go along. A lot of people are good in framing an issue. I'm not framing this issue. I am asking for the committee to study and to spend time on this, and we definitely want your input. This one, since it's a tutorial, so to speak, we welcome comments, put it in writing, and as we go along, the rest of our meetings will also be an area for public comment, and those who couldn't attend can also submit comments in writing. So having said all of that, I'm going to ask a member of our committee and an esteemed attorney if he will come up and give us an overall view of the history. Thank you. So he's going to.
Good morning. Madam Chair, thank you. It's good to see you again. I enjoyed that story very much. It reminded me of a prior EPD director, Carol Couch, and this may be apocryphal, but the story goes when she was out working on this buffer issue. I don't think it was the trout stream buffer, the 50 feet, but I think it was where we have the larger buffer above water intakes. I believe she was out in a public meeting in that regard and had the Magna Carta read to her, so by the public. Much the same idea, right? Hey, this tension with the public good that comes with these buffer protections is bumps up against private property rights that are very important too, and so some of that is available here. I am a member of your esteemed committee, which I find to be interesting. So y'all will.
I've got do not grade us because I know you are now a professor at the University of Georgia.
Well,
so
I told you, Madam Chair, that this presentation. By the way, I'm not a PowerPoint guy, as most people know me. I did get this done. I wrote it, but my son put it together, so I owe him a shout out. But I test drove this to my class. I have a Water Wars class in the SPIA school at Georgia, and so I did not do the whole presentation, but we were starting the course, and as you'll see a little bit here in a second, the whole country starts really, if you go back to Federalist Papers 11 and 12, the real tension with Articles of Confederation way back in the beginning of the country was we don't have enough of a union to protect and regulate interstate commerce. And interstate commerce back then was not railroads, it was not airplanes, it was not highways, it was rivers and seas and bays. And so navigation becomes like front and center and then the Constitution comes along and they have the Commerce Clause, which is an important provision of the Constitution that gives the Congress the right to regulate areas of interstate commerce. And as we'll talk about, I mean, that's been through our history. So it is interesting, and this is the reason I sort of mentioned this to the class, that here we are, however many years later, looking at navigation. There is a different law we got to look at, and this is one of the things to sort of sort out, and we'll all be talking about the different definitions of navigation and for what purpose the question is being asked. But it is interesting to see that you've got a recognition early in the Republic that, hey, we have to have a federal government that can help manage this interstate navigable resource, because it's how we can't have one state clogging up between each other. So it was all about that. And then now we find ourselves today talking about, okay, what does it mean? And the state sort of sits in that position that the feds were at the start of the country. Like, okay, in navigable rivers of Georgia, there's a recognition that there's a public interest in those being available and open. And so the state is the one that sits trying to balance that tension. And so that's why, from a course standpoint, we kind of teed it up that way yesterday. Madam Chair, I'm not going to try to be efficient with my time, because I learned yesterday that it was a longer discussion. But just quickly, just as a matter, I should say this. You just mentioned our good lobbyist friends, of which on some issues I am one, not on this issue. And so I want to be clear, I do not have clients that have asked me to represent them related to this issue. I represent industry groups and landowners, some of whom are interested in this and have interest in this space. But I just want this committee to know I'm here to just try to help as best I can. I don't have all the answers, but I think I can help identify some of the issues and some of the considerations and balance and history and how we got here. And I also was not involved in any of the litigation that kind of got us to this new chapter, nor the litigation that's going on now. So to the extent I say something, it's not on behalf of the state, even though for some of you that know my history, I got baptized by a fire in the '07 drought, working for Governor Perdue as his counsel, and then went out and did private practice for a while, and then Governor Deal asked me to come back and run EPD, which I did for about 5 years. Left when we tried the case in the Supreme Court for the water war, the Florida v. Georgia, and I've been back in private practice and dabbling teaching a little bit water law at the University of Georgia, and now this water wars course since. So that's my history. With that, I'm going to skip through these because I do want to be mindful of time, but this is one of the quotes from the Federalist Paper 2 with John Jay, where he's really just saying, look, remember the Federalist Papers are written to try to encourage the states to ratify the Constitution. And so one of the arguments is, hey, we got these rivers that are our main asset. Y'all
So
have it-
essentially,
I think y'all have it on paper.
our panel can't, that screen is blank.
But I
So,
think it's in your paper.
okay.
Well,
You
Well,
can't
but-
see that either?
you're really keen to present to them.
So let's do this. When this is over, we will be sure you have what your PowerPoint is. So everyone look to that. And
Are we good? I think I'm going through that, what you have a paper copy.
okay, all right, that'll help us. Thank you.
Okay. So this is so then early in the Supreme Court, we had this case, Gibbons v. Ogden. It's important for a lot of reasons in sort of constitutional law, but there was this question very early on, which is, okay, the Constitution has given to the Congress the right to regulate interstate commerce, and there was this fight in New York where New York, the state of New York, had given a monopoly to a steamboat company, but Congress had said, no, we have this lottery system, we're going to award steamboat operators licenses. And so you had a conflict. You had a conflict between what Congress law did, and you had a conflict between what New York did, and it was over the Hudson River, so what we now would view clearly navigable. But the question before the court was, is the Hudson River navigable, and what relation does commerce have to navigability? And so the court says, this quote here is, basically I'll go to the back part of the quote, yes, the power has been exercised from the commencement of the government with the consent of all. It's been understood to be commercial regulation. All of America understands and has uniformly understood the word commerce comprehends navigation, right? So there's this conflict on the river, big river, interstate river. Congress has regulated under the Commerce Clause, and the court resolves the dispute by saying, New York, sorry, your law conflicts with what Congress has said, and Congress has regulated under the Commerce Clause. So that's that's, again, federal law context, interstate river, and navigation is right at the beginning an important question. We haven't yet defined what is navigation. We're just dealing with, this is sort of common law, right, as the courts are dealing with these real live issues. So now let me just fast forward to how we got, by my estimation, to the latest activity around navigation, starting with some case law that led to activity in the 2023 session with Senate Bill 115, and then the work that you guys did, the study committee under Chair Burchett last year, and then the House Bill 1172, the action you guys took as a legislature last session, and then the House Study Committee we're in today on navigation. So I'm going to run through these just to bring us to today, and then let me just go to the end of the movie, Madam Chair. I think at the end of this presentation there's some background, but you didn't ask me to do this, but I took the liberty to say, hey, there once we've gone through this presentation, right, and gotten some background and some history, and we kind of understand terminology, you know, what might be teed up or not teed up, or what are sort of the issues around navigation, like where we sit in this evolution of sort of another look at our rights of access for the public for fishing, hunting, and passage. So I think the end of the presentation is my attempt to help sort of tee up some things, but hopefully we can get through this efficiently. So we had this Four Chimneys litigation in Upson County, and it dealt with Yellow Jacket shoals on the Flint River, which is right below Highway 36, for those of you that know the area. That picture I had as the opening slide is actually Sproul Bluff State Park. So the shoals there are not Yellow Jacket shoals. That's actually upstream of Yellow Jacket, where we have a state park and a public boat ramp. But you can see it's a wonderful resource. These shoals are, I'll let my natural resource DNR friends tell you all about that. But it's a wonderful shoal bass fishery. Obviously, the depth of the river around these shoals varies based seasonally. And so that's going to be relevant to the definition of navigability. But just to give you a basis, they look not unlike that at Yellow Jacket, right? So you got this great fishery. This is my view of it. So wasn't in the litigation, don't represent anybody. But there was conflict, and there's long been conflict on access, like passage. But the recent conflict in the Four Chimneys litigation was lawsuit against the state to compel the DNR commissioner to write tickets for fishing without permission on the stretches of the river that the landowners had, that they had the riverbed ownership title, ostensibly from grants by the state that predated 1863. Now we're going to talk about why that date matters, right, and our definition of navigability under state law in a second. So it wasn't a passage case, because under our state definitions, if you have a non-navigable, navigability was at issue in the case, let me say that. But they weren't trying to say, hey, because we have the ownership, because they didn't own both sides of the river there, they owned out to the thread of the stream. They weren't trying to say you can't pass in a kayak. They were trying to say you can't fish in this section. And understandably, there was a lot of frustration because a lot of the public, I think, were not only fishing, but littering and trespassing and camping on islands and camping on mainland. And as I understand it, things that are illegal, by the way, that'd be trespass and that'd be littering, and all of which are, if you can catch people, would be illegal acts already. But I think the belief was, look, if we enforce our exclusive right to fishing, it's going to take away the bait and the interest of people to loiter and be right in front of our property or on our property. So that was the genesis. Ultimately, the state, through the Attorney General's office and the Commissioner of DNR at the time, Mark Williams, on the eve of trial, entered a consent order before they went to trial, like that Friday, and it was like day 39 of the legislative session, as you guys will remember, those of you here in 2023, right? And it caused a big stir, because what the state did is it consented not on navigability, so they didn't agree on whether that section of the Flint was navigable. It's plenty wide, right? If you look at it, it's plenty wide, but it's this shoals issue. Is it navigable over the shoals? And we'll talk about why that's important. But the state did agree that the landowners had title that predated 1863, and therefore the state agreed in this one case under the consent order, and the consent order speaks for itself. So there's some legal implications of it. We can all talk about that. I'm not going to opine on that. It means what it means. But in the terms of the consent order, they agree that they could therefore assert an exclusive right to fishing over the river as it passes over the meets and bounds of their riverbed ownership. And the reason the states took that position was there was this main fishing case. I'm going to come back to that in a sec. But you had this main, I call it the Seminole Fishing Access case. This is Parker v. Durham from 1988. And this involves an oxbow called Hughes Old River. And I mix this up every time I call it Old Hughes River. Hughes Old River is an oxbow in Long County. Mr. Williams, almost down to you. Long County, and Altamaha River has a lot of these oxbows, right? Where the river was in one place, the main stem, big flood event happens, the river cuts a different course, leaves this horseshoe or oxbow lake. And so in this case, the plaintiffs had an oxbow lake, Hughes Old River, and they had leases for fishing. It was a great fishing lake, right? But in high water times, the river can be reconnected hydrologically or by high water with the oxbow. And so fishing public would come in off the river and fish. And so they naturally said, look, we own this thing, both sides. This is non-navigable. Under our law definition, we'll go to it in a second, that means we can lease this out over here and we can keep you from fishing public. Our Supreme Court case law back in the 80s and 90s is not, the cases don't read quite like they do today. Today you read this, if you read this case, my friends that are on the Supreme Court would have probably a 50-page order opinion for us to read. Back then we had like 2 paragraphs. So when this finally got to the Supreme Court said, look, there's this fight on navigability. We don't think the trial court, because it was coming up on summary judgment from the trial court, and so they basically said, look, that's not determined, so they remanded the navigability question, whether these oxbows were navigable or not. But the court just said just stated, look, they own the river bottom from a grant that dates pre-1863, and we're going to look at the statute, why that's relevant. And therefore, under the common law, we think that they have the right, this bundle of rights to exclude fishing. And that's Parker v. Durham. And so I think the state at the time is looking at I'm going to go back now. If you look at the key statute, you have OCGA 4483 that says, look, if it's non-navigable, you do have the exclusive control of that fishing right. Conversely, if you're OCGA 4485, you have this definition of navigability. As used in this chapter, navigable stream means a stream which is capable of transporting boats loaded with freight in the regular course of trade, either for whole or part of the year. So it's not. So the definition is, remember, this is 1863. So, are we talking about like vessel? There are questions, right? It's an older definition. Are we talking about vessels that are like Tom Sawyer on the Mississippi, or we got cotton bales on it? And, but there's a second sentence, right? The mere rafting of timber or transporting of wood in small boats. What's a small boat? A lot of questions about that application. Shall not make the stream navigable. So there's this definition of navigability. So if you're non-navigable, you have this exclusive right. If it's navigable, no. There's going to be different rules. And not unlike, for the same reason we talked about this back at the beginning of the Republic, navigable rivers are different. They've got to be open to commerce. We can't let one landowner block them. We can't let one landowner do things that impede the use of that river because it's a public resource. And then the second piece is subsection B, the rights of the owner of the land which are adjacent to navigable streams extend to the low water mark. So they're basically saying, look, they extend to the low water mark. So let me go forward. So Parker v. Durham's the Seminole Fishing Access case, and then Givens v. Itchaway is a case you hear a lot of people talk about, and people get them conflated, right? Because the fishing access case, I would say, is Parker v. Durham. The passage case is Itchaway, which went, for those of you that know Mr. Woodruff's Itchaway plantation that famously was 29,000 acres under one fence that is down at where Itchaway Creek is one of the main tributaries to the Flint down in my old neck of the woods in southwest Georgia, flows into the Flint in Baker County. That Itchaway Plantation, which is now still maintained, of course, and has the Jones Center, which many of you, Madam Chair, I'm sure have been to and been hosted at, doing a lot of great research around natural resource work and carrying on a great mission. But at any rate, Itchaway was having, as you can imagine, 29,000 acres under one roof. Under one fence. You can imagine the poaching challenges and control challenges of. So it's not unlike the issue that triggered the Yellow Jacket Shoals controversy. And so that litigation went all the way to the Supreme Court. It was over navigability because it was not about fishing. It was about passage. It was about, can you, in a canoe or kayak, can the public go through Itchaway? And folks will talk about whether that was rightly decided. You have a very colorful fact pattern where one of the plaintiffs, or at least one of the, and there are people in the room that know more about this case than I do, so I'm just sharing because it is colorful that there was some attempt to float a bale of cotton and a goat down the river to prove that it meets the 1863 definition. Not a bad idea, but didn't work. So the court found that Itchaway was non-navigable, and so we do have that case from '97. So when we get to this dust up that happens in 2023, right? Senate Bill 115 is passed at the 11th hour. I've got its text on the screen, and there's a whole body of law around this term you're going to see here that you guys excerpted in an amendment this year in 1172, but the whole notion of the public trust doctrine. And so I'm not going to give you the history of that. Certainly I know that was done in last year's study committee. But needless to say, there are a number of federal cases. When I say federal, I don't mean district court. I mean the Supreme Court that dealt with this issue of, okay, when the states, the 13 sovereign states became states and became states from the crown, what did they take? And then, so you have a coastal regime where, and I deal with a lot of these issues to this day, where the state inherited that coastal marsh, and we presume that unless you have a king's grant to that marsh, it's owned by the state. So we have a Coastal Marshland Protection Act, came in the 70s. It's been one of our seminal protective statutes to protect the marsh from threats of not just development, but mining, even at the beginning of sands and different things. And so that's because the state sort of has that public trust resource that has been clearly established for the coast on the marsh. But this federal line of cases clearly say, hey, look, and there were conflicts that would happen because people owned riverbeds and claimed the same thing we're dealing with now, which is, okay, if you do have title to a riverbed, what does it mean? Does it mean, like the old common law in England, that you could, if you owned the riverbed, it also meant you had the exclusive control of the fish in the water column above you? That's what the old English common law said. Totally different animal, though, because you have a British Isles with estuaries and creeks. You don't have a lot of this upland river situation we have. But nonetheless, that was sort of this common law around it. And so you've got this federal line of cases. I'll show you a couple of them. But the bottom line is they basically stand for the proposition that, look, the state is the one that inherited the ownership of the riverbeds, and then they set the contours of this public trust doctrine. There are some federal, the Supreme Court would say there are some sort of federal absolutes about that. But the state gets to, the language in this PPL v. Montana case is that the state sets the contours. So if you look at what Georgia did in 1863, it passed those statutes. So the state is, and it also granted the riverbeds, right, over the years. So I would argue it's setting the contours of the rules of the game here by activity, both state grants of riverbeds and by the statutes that were passed in 1863. And by the statute that was passed, Senate Bill 115, and by the statute that was passed last year, 1172. So the state is operating to set the contours of all this, subject to some things that are sort of protected. And there also in the federal case law, there is this notion that because navigable rivers are so important, as we discussed, even if you've got title, it doesn't mean it's alienable in the same way if you had title out here on some upland, because it's a navigable river, right? And we can't just say you can stop passage, right? Or you can stop commerce, you might argue. And so, again, it's all coming back to navigability for this big policy reason, right? And then you've got this underlying issue about, okay, even if we set navigability and understand that rule and its application in Georgia, what does it mean related to fishing and hunting if somebody owns a riverbed? Okay, so back to Senate Bill 115. That was passed, and it basically says, look, we believe that even if there was a state grant, and you have a state grant before 1863 when the statute was passed, that the public still retained the aforementioned rights, which was this list of fishing, hunting, passage, navigation, commerce. So when the legislature acted in 1863 and entered to set the contours of some of this, and even when a state grant was given for folks to have riverbed ownership, it didn't mean that the public lost access to navigable rivers. This is contested. This is in the case we're dealing that's litigated now. This is all out there, but that's what 115 said. And so it went to Governor Kemp's desk. He signed a signing statement that I have here that I won't read. You guys have read it, but just I'll point out in the middle of the signing statement, he's basically saying, look, the way I look at this, we got public resources in both stocking and in boat ramps, and so that's an important thing to recognize for the public's access to certain stretches of rivers. And there's nothing here that really changes what's navigable and non-navigable, and there's nothing in this bill that changes that gives anybody the right to trespass, and there's nothing. There's no, and this is important, and to the extent anybody asked me about this, I thought this was important at the time. There's no implied right of action in Georgia for this kind of thing. And so just because the public has this public trust doctrine, it doesn't mean that you just get to sue to challenge anything and everything because you just don't like it. There's no private right of action without the legislature changing it. So it's got to be expressed. The legislature, you guys would have to pass a statute that gives standing to do that. So he signed it, but he invited perfecting, right? He invited the activity. He referenced the study committee from last year and invited further work. So this led to the study committee work from last year and the yeoman's work that committee did, held 4 or 5 meetings around the state, well attended. And this is my list, so this is only mine. I break down the concerns with Senate Bill 115 into 2 categories. The first category is people that didn't like Senate Bill 115 and didn't like the intended consequence of 115. So these are landowners that say, look, I own this, and I don't like it. I don't like that you clarified that I can't exclude fishermen from this stretch of the river, and you're wrong, legislature. So that's the intended. The unintended, and I heard a lot from my clients in the unintended space, it kind of broke down into two categories. They were the folks that said, hey, this public trust doctrine reference in 115 is really problematic. If you look at the way public trust doctrine has been utilized or sort of employed by different groups to challenge different lawful uses, it's been an expansionary tool in the West and in other places to challenge validly issued Clean Water Act discharge permits, other things, licenses for fishing and different things like that in other states. And so there was this concern about, okay, this public trust doctrine could be kind of have this unintended, which is provide an increased standing for the public to challenge validly issued permits, those kinds of things. And then there was this other group of folks that were concerned, I think, with the unintended consequences of 115 around trespass. Okay, we've now got, yes, you can't go up a non-navigable stream if that landowner is not allowing you, but we still don't know what that is, that there's still this confusion in the law, and this is going to lead to more trespass because people are going to just say, hey, this new law passed, I can go up this stream and I'm going to do it and I'm going to push the limit. So I got clients that are concerned about that, I think legitimately so. So the study committee met last year. It's just a note, House Resolution 519, chaired by Representative Burchett. And then after a report from them, what came out of the session in last year was House Bill 1172. And in my efforts to get this slide done, I didn't get the strikeout language. I got what you see the underline, which is the new language, but I don't have the strikeout language in here. So public trust doctrine was removed. Some of this was tidied up. And then we have a new subsection 2, right, which just clarifies that none of this allows entry upon privately owned land adjacent to navigable streams. And so, the new language, the General Assembly further finds that the common law, the citizens of this state have an inherent right to use for passage and for hunting and fishing all navigable streams from the low water mark to the low water mark. So, again, what we've done, what you guys have done, what the legislature has done is kind of say, look, this public trust doctrine at the best is kind of a lightning rod that isn't necessary for purposes of what we're trying to do here. At worst, it could be kind of have this unintended consequence, which is gum up other lawful activities. And so let's just remove it and let's just be clear in the statute what 115 was designed to do, which was, look, if the river is navigable, so we still have the definition issue sitting out here, right? Do we have a clear definition that the public knows tomorrow, can they go out on which stretch of river? That's still out there. But if it's navigable, and we didn't change the legislature didn't change the definition of navigable, you can fish, you can hunt, and you can pass between the low water marks. Doesn't mean everything is solved, but it is, I think you guys did what the governor invited you to do, which was continue to perfect the legislation. All right. So pulling back for a second, you will hear a lot of different discussion about the word navigability or navigable, right? And so this is me trying to help sort of tee up the issues. So one of the first questions is, what source of law are we talking about? I mean, is the state definition that we've been looking at, that's been relevant in Parker v. Durham and relevant in Givens and will be relevant in some of the litigation that's going on now, is that the definition we're supposed to be looking at? And so, or is it some other definition of navigability from federal law or from federal case law? And so, I added this second question, which definition applicable to what purpose or to answer which question, right? And so let me illustrate why that's, and I'm not going to take this presentation from my EPD friends who can deal with this much better than me, but we hear a lot about remember the Commerce Clause authority that we talked about at the beginning of the Union. It's in the Constitution. It's part of Givens v. Ogden, right? When the Congress passed the Clean Water Act, it is, they don't regulate everything, right? They don't regulate every state water body, because they don't have the authority to under the Constitution. They only have the authority to pass statutes that regulate, that turn on what Congress, under its Commerce Clause authority, said it would cover. This is the waters of the U.S. dispute that you, if you followed the back and forth in the regulatory rulemaking process, that's what is at issue there. And navigability is a term that is used in that litigation. But it is not the same definition, nor do I think it's applicable to what we're really talking about here, because navigability under what is jurisdictional for the Clean Water Act is more like the size of that stream your friend was talking about in North Georgia, water quality of that notwithstanding. So I think you can put that to the side, but you hear that a lot. Well, now under the federal definition, any trickle is covered. Therefore, we've now opened the Pandora's box. And I would say, no, I think your definition that you're trying to get your hands around is our state definition for purposes of this bundle of state rights, the contours, if you will, of the public trust doctrine, the contours of this public trust resource, even though we took the language out. And so so that's Clean Water Act. The other place you hear this navigability term is around a concept called navigable servitude. And so, the Corps of Engineers and the federal government are doing all sorts of projects on interstate, on navigable rivers. They're dredging, they're doing all sorts of things. And normally when you impact private property like riverbed ownership or riparian owner's property, if you were to damage it or remove a structure, normally you'd have to pay compensation as a taking. But there's a whole body of cases that say, well, wait a minute. The federal government's got to be able to do its job to clear, the Corps of Engineers and other federal regulatory agencies got to be able to do their job on navigable rivers to keep them cleared of obstruction. And in some of these cases, the government's not going to have to pay compensation for those impacts. But that navigation definition, I would argue, is not the definition we're talking about, but you hear it a lot. Navigable servitude, how does that interact with the state definition? So I just point that out. There are also other federal law purposes of which navigation could be applicable, like in the tri-state water fight. We were trying to get the Corps of Engineers to operate systems differently under their authorized purposes. One of their authorized purposes is to maintain navigation, and that's a flow metric, like, hey, we need to release this much water to make it navigable, but not based on the contours of the clearing something, but actually floating enough water. So that's a different navigation question. So I just throw that out there, not meant to, I don't suggest those are the applicable definitions really at issue, but I want you to know that comes at you, right, when you talk to people. This is my one water law basic slide, which is, and this is, I have not had the Magna Carta read to me when I was director, for the record, but I've gotten really close. One of those places where I get really close is talking to some of my ag friends about whether they own the groundwater under their property. And I tell them, no, you have a usufruct. You have the right to use it. That's why you have to get a permit. Yeah, and they love that. But it's true. Water is a different resource, right? It runs off even in the aquifer of Florida, and it's moving. It's headed to if we weren't using it, all that water would daylight in the ocean one day. This was one of my jokes when I was director, this was how I was going to help the Obama administration counteract sea level rise. We're going to take some water for irrigation. But anyway, so you don't own the water. And I think now, because all the we have permitting regimes in the state. This is another place where I would argue that is a contour of the in essence, public trust. It's a contour to say that water is not owned. You have a right to use it, and the state sets those parameters. So if you have a withdrawal permit, I mean, if you want to withdraw more than 100,000 gallons a day under our Water Control Act, you got to get a permit from EPD, right? You don't, and when you get the permit, you get the right to withdraw it and use it. You don't own it. So even if we talk about selling something, you don't sell the permit, right? You transfer it. It's not a alienable entity. So I think people get that about water. They're like, okay, so if you own the waterbed, let's say, and have it a title that predates 1863, I don't think people are arguing about, well, yeah, we own this little piece of water running by, but when it comes to fishing, there's a different view, and it is based in an old common law notion from England, so it's not out of nowhere. But just we have recognized this in Georgia. It's a riparian common law concept, but it's adopted in all our case law. So you have the right to use it, not to own it. Okay, here are my last two slides, I think. And this is, and then I'll hush. But so, Madam Chair, again, you were not doing this, but I'm going to throw these ideas out to think about. We have a state definition of navigability. Is it sufficiently clear for the public, landowners, and law enforcement? It's not. It has elements that are very valuable, right? It doesn't say nothing. I mean, it's not just total. It's got some guidance, but is it clear enough? If the answer to that is, we think we can do a better job to help you or me know where we can go put a canoe in the river and go fish in Georgia, then what are our options to provide clarity? Change the definition in the statute. I mean, you guys look at that and recommend a different definition. How about authorize the Department of Natural Resources, Commissioner, don't shoot me, to promulgate rules in which I would say operationalize the existing definition. And I'm going to talk about some pros and cons in a second, but we got to get this into a workable definition and maybe provide so we don't change the definition, but we provide clarity on how that definition is applied. There's a big, and I'm jumping ahead of myself a little bit on the pros and cons, but there's a big benefit to the public process of a rulemaking that will come back over under the APA, the Administrative Procedures Act. It's going to come back to the legislature, so you get one last look at it before it becomes law. But there's some benefits to that. Then the third thing is, I know Representative Burchett, Chairman Burchett, introduced a separate bill that was a map, and so you could do that, which is some form of a map that, again, says we, the legislature, find that this is your list of navigable rivers based on the 1863 definition. So not changing the definition. Here's our view. And so there are pros and cons to all of those, right? Any change in the definition, I will flag, you're going to have takings concerns where somebody, some stretch of a river went from what was arguably non-navigable, which somebody could say you can't fish, to navigable. What does that mean? Well, it means that person's got to be compensated. How much? Well, how much is the value of an exclusive right to fish when you weren't leasing it? Or I mean, all these are issues. There's the line drawing problem with either body that does this. You're going to have it. Where does, how far up the Flint? Does it go up to Sproul Bluff? Does it go beyond? Does it go to the 16 bridge? Does it go to the 92 bridge? Is that all of that's always going to be a problem. And so if it's a problem, challenge, is that better to be done in a stakeholder process at DNR, which ultimately can be challenged, but once the rule is in place, has a lot of durability? Or is it better here? And I'm agnostic on that. I'll just point out that's a thing to think about. And so the last is sort of which forum, legislative or administrative, in terms of technical and legal input and public and stakeholder. And then last is, and I think a lot about this, having been at EPD, watched the federal rulemaking change the rules all the time. and Madam Chair, this is probably my biggest goal, maybe you would share it, is getting to a place where you guys aren't debating it every session, right, and spending weeks on it. So what can we do that's durable, provides clarity, and is durable? All right, last slide. We've talked about riverbed ownership. We've talked about the public trust doctrine. But I think there are a number of those things that are still going to have to play out. I'm not recommending that this body would necessarily think it needs to take on all those. For instance, if you provide clarity on navigation and you provide clarity around where people can go fish, that works its way through. There's still going to be some questions about, is Parker v. Durham still good law? What if you do have state bed ownership that predates 1863? Did Senate Bill 115, which is a statute now, and 1172 change Parker v. Durham? Because Parker v. Durham was a Supreme Court case based on the law existing at the time. The law that it was based on was common law. Now we have statutory law that says a different regime. There are going to be other sort of novel ideas about how to expand navigation through the federal case law. I don't think it's really valuable to go chasing the federal case law. I mean, the federal definitions. To me, you have a state definition. I think that's clearly the one that applies for these questions of fishing, hunting, and passage. And so my view is it's about that definition right now. And so what I would say to end is, if you told me, Madam Chair, that the goal was to find a perfect solution, that there would be no litigation, follow-on litigation, I'd say we probably should save our time because it won't happen. But we can think about the things that might make the amount of that less. And I know, Madam Chair, in our discussions, the idea that we got people on the riverbanks fighting with each other and dragging law enforcement in the middle of it, and in some case shooting at each other, is not good. And at the end of the day, if we can have, however we get there, in my mind, a map where we're looking at, we know we get online and say, okay, I can fish below this bridge or I can't. We've done a lot to help the public and landowners. And so with that, I'll yield the well or allow for questions.
And so thank you very much for this presentation. A lot to absorb, and I'm glad there's no test following it. So for the committee and for those listening, this is our learning session, so to speak. And with the members of the committee, we'll be asking the questions, but I'm going to ask each member to go through the chair with your question, and we will do one question each in fairness, and then we'll loop back around for other questions. Keep in mind, this is just the beginning. And also, it's going to be interesting for me because we got a few attorneys on the committee, but we have a few good old boys and one girl on the committee. So it will be a back and forth, which I hope is reflective of where we're trying to go for the citizens of Georgia and the visitors to our state. So thank you very much for this. And if I cut off, try and keep our time, we have other meetings, and it's up to the will of the committee how many meetings we have and where our discussions go. So at this time for our committee, if you will press your button if you have a question. If you need 25 hours to try and study what he just said before you ask a question, we have other meetings coming up. So it's not imperative that anyone say anything, but our committee members will. This is a tutorial, so we're trying to learn and understand. Just don't grade us, and you got to fight us for the final version too. So anyway. Yes, just state your name and ask your question.
Stan Gunter, and I remember riparian rights in law school, and that's about the last time I had to deal with it until I got here. I'm trying to look at this in maybe a little different way with the statutes in Title 44, Chapter 8. That really sets out the rules for accessibility to streams, or no accessibility to streams. every way I look at this issue, I can't see where it doesn't end up being a taking. And even if I look at those statutes, if we were to amend them and set out the rules of access, because up in my area I have Helen, Georgia, which has the tubers that go down the stream there, and that's not a navigable stream, and any property owner along that way could probably stop that business. And that has that business owner worried. So, you know, I don't know if any changes in Title 44 would help and not result in a taking or litigation. I think there, any way we look at this, it's going to be litigation. Have you?
Yeah, I mean, I agree with you. Any change in the definition opens up the potential for individual cases that can present takings. But your concern in Helen, for instance, is the Chattahoochee navigable up there where all that tubing's going on? I don't know. I don't think so. And therefore, it is true that if you own both sides of the river, you could try to stop them. And that'd be litigation over that. And navigability would be the issue under the existing statute. So that is why I was thinking, hey, instead of just leaving these statutory definitions and leaving the public with no idea what, and leaving DNR kind of having to just administratively decide. If you didn't change the definition, but you tried to operationalize it in a rule, and the legislature gave the DNR the authority to do that, maybe with some guardrails. I mean, there's some things to think about. Hey, we want you to do this, but we don't want it to expand, or, you know, however you might want to build some guardrails. But it is a definition from 1863, and so what would be attempted to be done, I think, over there, if you were doing it, would be to, again, not to expand it, not to shrink it, not to change it, but go through a process that's defensible from a regulatory legal standpoint based on multiple lines of evidence. So it just wouldn't be, hey, you know, here's some historical data about where some commerce was going on the river in 1863, but, you know, where are our public boat ramps? I think that's a pretty valid line of evidence for what is navigable. That, you know, that being different than where you can get a kayak. I mean, there are some, and then, so the definition has some things that you are still valuable if you were trying to approximate what that means and provide clarity to the public. But I don't disagree that takings is out there. The one thing I'll say about takings in the example you're talking about, though, it would be the opposite would be the taking. The taking would be a section that's non-navigable that becomes navigable, where the landowner was saying, I had a lease for this fishing outfit or whatever, and now I can't provide exclusive fishing rights anymore, and I lost this. Because you still have all the other bundle of ownership, right? You didn't, and there's a lot of takings case law, the Lucas case and others that say back to inverse condemnation that say you have to take all the value. There's also some other state takings cases. So it would still be a question of fact in that case if you said, well, look, the legislature changed it. It was non-navigable. Now it's navigable. I lost this. What was taken from me is my control of fishing is an exclusive right. What's the value of that? That's another fact question, right? In your case, you got a business owner, commerce, that he might have some interesting dormant commerce clause kind of challenges to bring before a court. So I don't disagree. He shouldn't and wouldn't sit by and let that happen, I wouldn't think.
Right.
And you hope that the long line of the grant of that public access and the fact that you really do need to have both sides of the river would keep that from happening, you hope. But I think the concern on takings is one of the main ones with changing any definition.
Thank you.
Thank you. Let's see. Number 24 is next. State your name and ask your question.
Representative John Corbett. First, I just want to thank you for putting this in this Chairman Tom McCall, you say non-lawyer language. I certainly appreciate that, where we can understand it. I'd like to say I think Whipper Chet done a good job last year with 1172, trying to thread that needle for us, low water to low water.
Yep.
But then I go back to look at the definition of navigable, where it says whole or part. What is there a definition of what part is part? Can it be 1 second, 1 day, 1 month? I mean, is there what constitutes a part of a year?
I don't know. I think that instead of, I can't answer that in terms of what that means fully, but I can say what it also doesn't mean, right? It doesn't mean that if a river gets low in the summer over shoals, it's non-navigable, right? It doesn't have to be navigable all the time. So we know that, right, from the definition.
Right.
This is another good example of complexity around which a rulemaking or you guys could provide some clarity around what the definition is, not changing it, Representative Gunter, but what it is. And I think if let me talk in terms of regulatory law. If you're using a real rulemaking process using multiple lines of evidence and you interpret that statute sort of reasonably, I think you're gonna, there will be some clarity. Now, sidebar on administrative law, we have a new Supreme Court case that came out overturning Chevron deference, right? The old deference that was given to administrative agencies. We never adopted Chevron in Georgia, so our Supreme Court doesn't say just because EPD passed a rule, it's going to be given a bunch of deference anyway. So I don't think this changes if DNR does a rulemaking, but I will say the best you do on that, whether you guys do it through the committee process here on a piece of legislation, or it's done in a rulemaking with technical expertise, the more you really wrestle through the right answer on that, I think it can be defensible. Even though it's absolutely true, it doesn't tell us how long it has to be navigable.
Thank you. Now, number 22.
Thank you, Madam Chair. Al Williams. Thank you, Mr. Turner. And to piggyback on my friend, you have taken a giraffe question and reduced it to the ability of goats.
Yeah, I didn't do that.
That's a good job. This is my second bite at this apple. I
Right.
served on the first study committee. And Madam Chair, glad to see you chairing it. There couldn't be a better person, more even-handed. I've spent 22 years in the legislature, and Chair Lady, as she stated, was one of my first friends. I guess she was now in the majority and I was in the minority twice. So somebody will get that after a while, Chair Lady. But
we're still friends.
forever and a day.
Yes.
Forever. And that's the way it should be. I'm so glad that this study committee says navigable streams and related matters. We're dealing with a matter that's primarily North Georgia. And we're dealing with the state's interests. We're dealing with landowners' interests. And we're dealing with small business or commercial interests. That's quite an operation. And from a similar standpoint, I'm hoping that at some point, Madam Chair Lady, we can discuss the problem from a water standpoint with the water wars that are being created in southeast Georgia by EPDs, mandates on withdrawal permits, stifling a lot of development. I'm just a plain-spoken Gullah Geechee from southeast Georgia. I'm not quite as graphic as the gentleman was some years ago. But I'm really concerned, and as I listen, how do we pick this jello up and have any left once we get it up? Because there's a lot of passion on both sides of this question, an awful lot of passion. And I've learned a lot about trout streams in North Georgia, getting to see where Stan Gunther lives. And, you know, it's interesting. And I spent all these hearings, Madam Chair, and all I got was some trout dip. We don't dip much in southeast Georgia. We eat fish. So it's going to be interesting to see if I'll see a real trout on a plate before this one ends. But that might be the easiest part of this whole study committee. Where, and you posed a couple of questions, where do you see? You mentioned a pathway. I want you to reiterate the pathway to where we have all three entities never satisfied but acceptable, and not like, after listening to many citizens, some people felt seriously betrayed by the agreement that we had that created the first study committee. And I you know, Navigable, and there were some streams like the place we went one evening, Judge, where you could literally stand in the water and it might get above your ankles. So we know that's not navigable.
Right.
But there are a lot of questions here. Where do we suggest with this committee, where do we head to find success?
It's a great question in the sense that I think what you said at the end is true, right? I think if we all sat down and said, okay, the Altamaha is navigable.
Yes.
The Flint, for most of it, is navigable. The Chattahoochee is navigable. The Savannah is navigable. I mean, but how far up? It's the line drawing problem. Yeah. And then tributaries, and then some features like in the middle of the stream when you have shoals like this fight started on. So I think we're not as far from some clarity on that as, so I'm looking at it the other way. We really do know a lot, and then we kind of know, like the Sequoia, for instance, I think was part of a big concern because it's all privately owned and it has these nice fat trout that have been fed by the landowners to go, and they have a big business to lease out all that. I don't think it's navigable under the current definition. I think the study committee said that 50 times, and nobody believed them, but it's not. And DNR says it's not, right? So we got some consistency and some historic precedent on that. There are some tougher rivers. The Toccoa is one. There are some other places, how far up the Flint, these shoals, there are some difficulties. So to me, it's not about we don't know where anything is, right? We do. We just have this other thing. So what's the right way to move forward with those three sort of disparate interests? I really think this is what the regulatory process is designed to do. And it's not that y'all would be just kicking it over there without any guidance and without, under the Administrative Procedures Act, seeing it come back before it becomes law. So what that process does, and it's not that your process in the legislative body doesn't do this, but it's just a forum in which there's public notice and comment and technical advice and defense, and then these guys, if disaffected by the rule, get to challenge the rule, and the rule goes through its own defense. And when it comes out of the back of that process, whether it's immediately or it has to go back for more work, but once it finally is in law, in reg, I think you have a process where people will grouse about it. They'll grouse about the process, but by law, they have a lot of guaranteed process right, due process. And so on the end of that, I think you have a durable product in that sense. And the chance for people to have been heard. I remember when I was in law school, I had this Civ Pro professor that did all of his research on the public's view of the legal system. And this is what his research said. You know, if you go from litigation, real litigation, to arbitration, to mediation, guess what people feel best about, irrespective of the result? Mediation, right? Because the legal system is real binding and keeps you from being heard. And so if if a rulemaking's done well, people get the chance to be heard. It's same in the legislative process, but a little different, a little bit more prescribed. And so what I would say is the opportunity for you guys to help set the course here and then maybe authorize a rulemaking or do it yourself is I think, preferable to just saying, let courts
Yeah.
deal with it one by one. So there's no perfect solution to the way forward, but there, I think, are better routes. And the worst route to me is do nothing and let everybody litigate every stretch from now on.
Thank you. And now number 18.
Thank you, Madam Chair. Again, my name is Johnny Chastain, and I'm from up in the 7th District. And it's an honor for me to be here today, even be on this committee. Appreciate the comments the Madam Chair made earlier about new folks
Did you
being involved and coming on board. I appreciate that. And also, I helped make that trap deal. Mr. Representative. So I hope that was good. If you come back to Blue Ridge, we'll get you a fish. Yes. But glad to be here today. And a lot of our, I know we've got to look at this as a whole for the whole state, but my district will be definitely a lot of non-navigable streams where we're at. And that's, I think everybody, a lot of folks will agree on that. We do have some of the streams like the Toccoa that have, some navigable, maybe some non-navigable part of the upper Toccoa, but and I think that's going to be our big challenge. It was, I thought, as Representative Corbett mentioned earlier, 1172 last year that I voted for, that took some of that, the public trust doctrine out of the 115, SB 115 that came up the prior year. And then the 1397 that give us an opening to start naming streams navigable in Georgia was a good start. And again, I think the whole thing to me is, again, is it navigable, is it non, as you've eloquently stated this morning several times, is it navigable and non-navigable? And as Mr. Gunner has already mentioned, from where's that cutoff at? Where does it, if it's navigable, where does it become non-navigable? And so that's some of the things that I'm trying to get my head wrapped around for our district and for the whole state.
The one thing I would say too about North Georgia that eases and complicates, but eases a lot of the public access issues is you got a lot of federal land up there. So you do have some public access that you don't have from a landowner standpoint in some other parts of the state. That doesn't mean the definition of navigability still has to be applied to the individual water body and work it through, but that is just a practical reality that up there, even if a lot of that's non-navigable, that doesn't mean there's not some public access in North Georgia.
Let me see. So number 19, let's go to you, and then we'll get back
Okay.
to you so we can do it that way.
Thank you, Madam Chair. The land grants, we ran the Cherokee Indians out of North Georgia and then Georgia. I forget the time period of that. Do you remember?
No, I've got, Ferris Cadle's land surveying book, so I could bring it next time and we can look at it. But yeah, we've started breaking up and doing land grants all over the state.
And those grants would have been different than the King's grants.
Correct. They're state grants, so they were done by the state after statehood.
Okay, all right, thank you.
But many of them before 1863.
That's,
Okay, Representative Chastain.
Thank you, Madam Chair. One other comment that's not brought up a lot, I attended a couple of the study hearings last year and hosted the one in Blue Ridge, and it's always, we're talking about the passage and the fishing, but the hunting part of it, we don't talk a lot about it. In our district, especially up in Blue Ridge and Ellijay, on these truly non-navigable streams, we'll have to, if portions of those were ever made navigable, if many of you have been to our communities up there, there's houses all over, even the Toccoa, but a lot of these smaller streams, there's houses all over those those streams up there, built $1 million homes. So that's a big, with DNR, I'll have some questions with them too with that. But, hunting is something that we don't talk a lot about, but it's an issue.
This is not a legal answer to your comment, but as somebody who is, I'll say I did this in Virginia at law school more than Georgia, but floating big rivers with the canoe and shooting a few wood ducks. I've done that, and the problem with that is if it falls on the land, right? How do you retrieve it? So, I think what I would say is, the law is going to allow in a navigable river, some floating and hunting, but be careful on the trespass.
Thank you. And number 22.
Thank you, my distinguished representative from North Georgia. The removal period for the Cherokee was between 1837 and 1838. And I've pondered all of my adult life how do you grant something that you did not own to grant? Just a clarification.
Well, we've done a lot of that in the history of the country.
So I think we're near the end, and the only conclusion I have is that we're going to have trout on one of the places we go. And to Al Williams' comments, we now have a wonderful mariculture going along the ocean with our oyster beds. Georgia is now on the table with easy-to-sell oysters. So there are always some good outcomes. To the rest of our panel members, be thinking of what we eat, and we will have certainty at least on that one thing. These issues are so very complex to those who are listening, and we have the right people on this committee to enter into this debate. So I feel really good about that. When we're talking about our national water law, I was always told that law is different west of the Mississippi and different east of the Mississippi. So if you could put that out there for people to remember, because I don't want to hear what California's doing.
Yeah.
So, okay.
Well, right, Madam Chair, the underlying water law is wholly different out there. A lot of folks think, I thought, when I first started doing this stuff, that, it's arid out there, so they probably have more protective water use and more conservative water use. And it's just the opposite, right? Because when those states were being developed, they were trying to encourage the transport, the diversion of water to get it from a river over here for a mining operation, or to develop a piece of property, or for farming. And so what they had to do before somebody would spend a lot of money to invest in an intake system and pipe it somewhere, they had to guarantee them that they would have that right. And so they have a prior appropriation system, which says if you had it first, you have it. And so there's all these priority of rights. We don't have that in the East. Riparian system means if it's a drought, everybody's supposed to reduce together so that you leave enough water in the river for your neighbor. So much better, and it does cause a body of law to develop around neighbors fighting over each other, because they're like, well, look, you didn't leave enough in the river for me. But it's still a body of law that says we're all sharing this public trust resource, this water, in a way that we have to do it together. Out there, they're moving back towards us because they can't afford the prior appropriation system. And out there, if you didn't use your allocation, you would lose it. And so they would just use it. So no conservation, right? So next year they still had the same allocation. Not a very conservative water system. And so it was just the opposite of what I thought. I thought, we got so much water in the East, we probably have a less protective underlying water law system than the West, but I think it's the opposite.
Thank you. And thank you very much. And we'll move on to our next presenter if you'll get ready. But also, take a moment here to talk about the legislative body and the governor's office. Since I've been serving since 1997 and chair of this committee from 2005, I can tell you that we are a resource to several of our states now, because Georgia has taken the time to have the difficult debates on what to do by way of being good stewards of our water. So as maybe these debates get a little bit awkward, we are way ahead of the pack in how we manage our resources. And so I think that needs to be noted about the leadership in Georgia. And so for our next presenters, if you'll introduce yourself, and I think it's Representative, sorry, I didn't mean to do that to you. So, Director Cowan.
Thank you, Madam Chair, members of the committee. I'm Jeff Cowan. I'm the Director of EPD. I'm finishing my 1 year today. I get through 1 year. I always surround myself with smart people. Today you're going to hear from one of my smartest folks on our team. Dr. Anya Trzynski is going to give you an overview of our watershed protection branch and how we deal with water every day.
Thank you. And Anya, thank you for presenting this. You have a very difficult job to do, and you do it with a lot of grace and knowledge. So thank you.
Thank you very much, Madam Chair, and thank you all for giving me the time this morning to give you an overview of the Watershed Protection Branch with a focus on our Clean Water Act programs and regional water planning. And I'm going to start with just a really broad overview of the Environmental Protection Division. We're led by Director Jeff Cowan, and he, like the DNR Commissioner, Walter Rabin, reports to the DNR Board. Now, the Environmental Protection Division has 3 branches, each dedicated to a different environmental media, one for air, one for land, and one for water. We're supported by a state laboratory that runs all of our analytical tests, and we do have a lot of analytical tests to run, as well as district offices located throughout the state where our district staff are able to go out immediately to respond to complaints, concerns, and do some compliance assistance and enforcement action across the state. The Watershed Protection Branch supports EPD's mission, vision, and goals by protecting and restoring our water resources. And we have a lot of different tools in the toolbox that we can use to do that, but one of the ones I'm really going to focus on today is permits. We issue permits for the discharge of treated wastewater and stormwater. We issue permits for the withdrawal of groundwater and surface water. And we also issue permits to public water systems. And then there's a compliance component that goes along with all of these permitting programs. We have some programs in the Watershed Protection Branch that are authorized solely through state-level statutes. A good example of this is the stream buffer program, stream buffer variances that are in the Georgia Erosion and Sedimentation Act. That is a state-only program. But we also have delegated authority from the Environmental Protection Agency for the Safe Drinking Water Act and the Clean Water Act. That means that we get to write and issue the permits, and we also get to take the lead on compliance assistance and enforcement issues related to drinking water and to clean water. Now, even though we have this delegated authority, EPA does maintain oversight, and they do that through a number of different ways. We have regular work plans that we develop with them that allow us to get federal funding. We also have them review some of our permits. They approve rules related to drinking water and to clean water. They do oversight of our compliance activities, and they regularly come in and audit our various programs. So even though we have this delegated authority, we do not directly implement the Federal Clean Water Act. Instead, our authorizing statute is the Georgia Water Quality Control Act. So I want to highlight that. I also want to again note that that's not the only way that we ensure safe and clean water. There are other statutes like the Georgia Erosion and Sedimentation Act that give us some tools to make sure our water is clean. So what's the general framework for how we manage clean water through the state of Georgia? First, we have to figure out what our water bodies are and how we want to use them. This is called establishing our water quality standards. So first, we go and find a designated use. We say we want to use this water for drinking water, we want to use this water for fishing, we want this one for recreation. We figure out how we want to use all those waters. Then we figure out how clean does the water need to be to support that use. So let's say that you want to have a water body for fishing. We know that if dissolved oxygen gets too low, the fish can't survive in that water anymore. So we need to have sufficiently high dissolved oxygen to support the kind of fishery that we want. So we've got some standards for freshwater fishery, for cold water fisheries like trout, and some standards for warm water fisheries to make sure we've got dissolved oxygen where it needs to be. And going through that process, we set these numeric and sometimes narrative standards for how clean that water needs to be so we can keep using it the way that we need to use it. Well, once we know what we want, we have to figure out what's actually out there. So we do a lot of water quality monitoring all across the state to pull together this data. But data doesn't mean a whole lot without interpretation. We need to be able to connect that back to something. And that's where the water quality standards come right back in. If we know how we need to use the water, and we have the data on what the water body is actually doing, we can see whether or not that designated use can actually occur. So if we come back and the data looks good, the bacteria isn't too high, the dissolved oxygen isn't too low, we can say that a water body is supporting its designated use. That's great, we're happy, that's a success story, we move on. But we do have situations where we get data, we look at the water quality and we see that the bacteria levels might be too high, or the dissolved oxygen might be too low, and that water body can't support fishing or it can't support recreation. And we identify that as an impaired water. This problem is not exclusive to one part of the state. If you look at the map over there, we've got green lines, and those green lines indicate where we have water bodies supporting its designated use. Those are clean waters. You can see those across the state. The red lines are where we have water bodies that are not supporting their designated use. Those are water bodies that are impaired and where we need to do more work. And again, you can see that those are also all across the state. So how do we fix these water quality problems? Well, we come up with a plan, and that plan has a very specific name. It's called a Total Maximum Daily Load, or a TMDL. It's basically a pollution budget. It means we take some allocation or some amount of a particular pollutant of concern, and we give it to the point sources, and some amount that's given over to the non-point sources. So a point source is what we typically think about when we think about a discharge into a water body. It's a pipe, there's water coming out of it, it's treated wastewater or it's stormwater, and it's going into a stream or into a river. We regulate that using National Pollutant Discharge Elimination System, or NPDES permits. And those permits have specific limits and best management practices in them to make sure that the water body we're discharging into is protected. But that's not the only way that pollutants can get into a water body. They can also come in off of runoff. So when it rains, that rain comes across a landscape and it can pick up different pollutants or different things of concern and put them into our surface waters. And there are a couple ways that we handle those non-point source pollutants. There's some state regulatory programs that we use, again, like the stream buffers. By protecting that stream buffer, we're protecting the stream. There are also a lot of incentive programs that we use, things that help encourage good practices to make sure water quality stays high. And a lot of those are supported by our statewide non-point source management plan and our 319H grants. So those are grants that we get from the federal government and then give down to local communities so they can do things like install agricultural best management practices or rain gardens, things that are really going to help water quality in the long run. So once we have the plan, we have to actually implement it. And we do that through permits, through buffer variances, through 401 water quality certifications, and through outreach programs. We've got programs where we work with school children and educate teachers. We also have things such as Rivers Alive, where people actually go out into the rivers and streams and pull out literal tons of trash, making our streams and rivers cleaner. And the final component, making sure that all that implementation was working, is compliance. And again, EPA has a good deal of oversight on our Clean Water Act related compliance. But when we talk about the statutes for clean water, those statutes don't only focus on water quality. There is a water quantity component as well. And there are a few other statutes that we have in place where we manage the water quantities in our surface waters and in our groundwaters. Like Mr. Turner mentioned, we have to issue permits for withdrawals from waters of the state of more than 100,000 gallons per day from both surface water and from groundwater. When we talk about our surface water withdrawal permits, we have a few things that we need to evaluate. In particular, the need for the water. We need to make sure that folks really need the water that they're asking for. The safe yield of the water resource, so how much can we really pull out of that specific water body? And then also the impact of that withdrawal on the source and on other users. We don't want to create a situation where we're pulling so much water out of a stream that a downstream user can no longer use it, or we've really pulled everything out of that stream. To further make sure that we're protecting our waters, we have some requirements in our surface water permits, and there are two in particular I wanted to highlight. One are water conservation plans, and the other are the drought contingency plans. Water conservation plans include activities that the local utility selects to help improve water conservation. It can be things like reuse and recycle, it can be things like long-range planning, and it can also be education programs focused on water conservation. On the drought contingency plans, this would include things like potable water use priorities and low flow protections. All of these permitting programs are captured in Title 12, Chapter 5, Article 2 of the Official Code of Georgia. And in that section, we have a definition of waters of the state. We issue permits related to waters of the state. We do not use the federal definition. Our definition is sufficient for our delegated authority from EPA, and this is the definition that we use for our permitting decisions. For permitting purposes, our waters of the state definition has nothing to do with navigability. So I've included that definition on the slide so you can take a look at it and read through. There's no reference whatsoever to navigability. These permitting processes require a lot of technical work, a lot of technical thought, and fortunately, they are informed also by planning. In the 2000s, the state identified the need for good planning, particularly when we are hitting times of drought and water scarcity. And as a result, in 2008, we developed a statewide water plan, which set the framework for how water planning was going to move forward afterwards. And in that framework, there was a big emphasis on regional water plans. The idea is that if we can break the state up into these regions, we can hit the local priorities, and we can use local knowledge to guide water management decisions. The map over here shows the different regional water planning areas. I will note that the Metro Water District around Atlanta has its own enabling legislation, so they have their own planning process, but it aligns really well with the regional water planning process that we use for the rest of the state. So these first regional water plans were developed in 2011, and they've been updated in 2017 and in 2023. And with the regional water plans, we have regional water planning councils. These are 30 people who have been appointed by the governor, the lieutenant governor, and the speaker of the house, and they are local leaders in the water sector or in businesses or industries or other areas that are really closely tied to water and that are really significant for that region. So we get a good regional snapshot. The council determines the vision and goals for the plan, and they also help us identify where there are gaps, where what they want for the water resource doesn't necessarily match what the water resource has. The councils are supported by EPD. We do a lot of technical work to help inform their planning process. One thing we do is build demand forecasts. We work with technical stakeholder groups to figure out municipal, industrial, energy, and agricultural needs in that area, projecting out over longer time horizons. We also go in and we do resource assessments. How much surface water is available here? How much groundwater is available here? How much assimilative capacity, or really how much can we discharge back into these surface waters and still maintain that good water quality? So we provide all that information to help the council then set good management practices and build a plan going forward. And I really want to emphasize that we have a lot of technical data that informs modeling work that gets done to identify all of this availability. So with our groundwater availability, our assimilative capacity, our surface water availability, we have models for each of those, and we run those models with the information that we have to identify where there might be gaps and what our water needs are. That information is then used by the councils for their local decision-making and local best management practices. So to give kind of a tighter example on what that means, EPD might develop specific metrics which will tell us something about how much water there is. So for water supply, we'll have a metric about how often the flow is below an in-stream flow protection threshold, or we might have information about assimilative capacity in terms of how often flow is below a different type of threshold that we use for water quality modeling, and that helps us see where these gaps are. but it's really the council that looks at that information and says, okay, what are the specific flows that we need at different locations? What kind of metrics do we want to pull into account? What do we really want to highlight and protect and emphasize for these plans? And the plans are very important. The plans guide our state permitting decisions. They are particularly important in our water supply permits, but they also inform our water quality permits, and they also inform loan decisions. The plans reflect these local water challenges and priorities, so they're well tailored for the needs of that area. And one way that we make sure that these plans are implemented is through something we call seed grants. These are little grants that come from the state. We pull them into EPD and then put them out to local communities, local universities, to make sure that the best management practices that are in these plans are getting put in place and that we're seeing water management go in the direction it needs to go. And with that, if there are any questions, I'll be happy to answer them.
Thank you very much. You said a lot that it seems like it's accepted, been done, and I can tell those listening to the committee, that took several years to get to this point, and very difficult votes. Agriculture was our largest industry at that point in time. The battles were with our neighboring states, and not all their water permits were easy to identify. Everything was on paper. And to go through that process, to watch our farmers figure this out in the fairest way. So you did an excellent job of bringing us up to date, but I can tell you, back during those days, we might have a committee that determined we needed another committee the next year to study what that committee had done for the next committee. So this answer for us, what we're trying to do, might not be a simple solution either, but I'm still in awe that the legislature and the citizens of Georgia have gotten us to this point. And I need to say again, the state of Georgia is leading the way on a lot of this, and I thank you for what you do.
Thank you.
Now to questions, number 22 and then number 18.
Thank you, Madam Chair. Mr. Director, I see why you yielded to her. Well, if you worked for me, the only thing I would have written is always yield to her. Wonderful job. But thank you all for what you do. It's whenever the word regulatory is anywhere in your mission, you're going to develop some real pushback. I mean, it's just a thing. And because you have that 100,000 gallon kick in, most average people have no idea what EPD does. My wife worked for many years for EPA, and I started telling her, no more reports, you're scaring me to death. I don't want to know anything about my water anymore. But have you looked at, I know some time ago, and I can't remember who, mentioned that there might be another look at your mapping for withdrawals. Because the big thing is, and as chairman of the Development Authority in Liberty County, it's tough to understand how a person next door can get all they want, and you can literally step over, and you're severely limited. It's kind of like the old deer dog hunting debate. You know, deer dogs don't know when the deer crosses a property line, and that water does not know when it crosses a line. I know because of some saltwater intrusion in the Floridian aquifer was one of the big driving forces for doing this. Understand there have been some reliefs recently, and because of the distance of a county like mine from the Savannah area and from the Brunswick area, where one of the main intrusions were, that we're not as impacted. Are there any plans in the future to take another look at the drawing and maybe make some adjustments?
Yes, sir. That's a great question. And what you're referring to, I believe, are the red, yellow, and green zones around the city of Savannah. They were all put in place based on the amount of impact from our groundwater withdrawals from the Floridan aquifer on saltwater intrusion on Hilton Head Island. And you're exactly right. We've seen a huge amount of improvement. There's been a 40-foot increase in that cone of depression in the Savannah area, and that is a testament to the hard work of the local businesses and water utilities to get that done. We are in a position now to come back and start having some conversations about what that needs to look like moving forward. So we had stakeholder meetings in about a decade ago where we identified 2 series of cuts that needed to occur in permits in the yellow zone and the red zone. That next series of cuts takes effect January 2025. And that's going to be a really good time for us to bring everyone back together and say, what are we going to do in the next 10 years? What does that next horizon look like for us? And we're hoping, to take a word from Director Cowan, to rebalance things, because we know surface water is going to have to be a big part of it. But we want to make sure that where the groundwater is the best resource, we have that available, and where surface water is the best resource, we have that available. So we're trying to think a little bit big picture, a little bit outside the box, and have those conversations starting, I believe, in about 2025.
Okay. Quick follow-up.
Yes, sir.
Madam Chair, if you don't mind. Quick question is it possible before the stakeholder hearings to have an informal meeting? We've got about 3 counties that's in a joint regional. I'd just like to have an informal conversation with the director, and director, if you'd come and just turn it over when you get there. But we'd like to certainly, we'd like to extend the invitation to start the conversation so that we'll be on footing. Okay.
We'll be very happy.
Thank you.
That's what you call legislative privilege right there. Number 18.
Thank you, Madam Chair. I appreciate the presentation today as well. One quick question. Under the ecological metrics, fish habitat, could you tell me just a little bit about what that is?
Absolutely. So where we have, we've had a couple of councils that have wanted to use some of our more refined models to get a better idea about flows really, really refined in their basin. And they'll look at what they think is important. And in some places, what that means is they know they've got a really good fishery, and they know that they want to protect that. So we look at what kind of flow do we need so that we have enough habitat, we don't have these open banks, we're not dropping to these really, really low levels, so that we can continue to maintain that really good fishery. So it's a little bit big picture, very much though focused on flow, and how do we make sure we protect that flow so we're not harming someone's livelihood or not harming this wonderful resource that we have in the basin.
Perfect. Thank you.
Yes, sir.
Thank you. And that question led to another question, number 24.
Thank you, Madam Chair. Thank you for the presentation. My question, we haven't had a drought in a long time, so hopefully we don't. But whether we have a drought or not, the population of Georgia is increasing, especially around Atlanta. What can we do to make sure that we're prepared for, say, 2050 when we have 4 million more people around Atlanta, to make sure we have the water to supply those?
Absolutely. That is a great question. I think that was a lot of the discussion that was driving the development of the idea of these regional water plans, because that's what the regional water plans are intended to do. They're intended to say, here's what we think population is going to be doing. Where do we have water resources available? Where can we continue to supply water from? And where do we have water resources that are really abundant most of the time, but in times of drought, we may not want to necessarily go to those water resources. So it's very, very active planning, and that's also where the water conservation efforts come in as well, because we found that we can get some really significant impacts just from being a little bit smarter with how we use our water. Different utilities go through water loss audits to make sure that they are running a really tight system. We've got great scores and great reports there. Those water conservation plans are big. And of course, Metro Atlanta with the Metro North Georgia Water Planning District has done some very, very important work with their regional plan to ensure good water conservation.
Thank you. Number 18.
Sorry, Madam Chair, just one more question. When you guys are doing those studies on the creeks as far as erosion, do you take in consideration like the canopies over the tree planting or the trees over the creeks?
Yes, so tree canopy is very important.
Yeah.
That's something that's reflected in the Erosion and Sedimentation Act, and something that's reflected when we talk about variances, because you get so much benefit from the tree canopy. Shading means that you've got lower water temperatures, that's better for the fish. You've got more dissolved oxygen, that's better for the fish. And you've got this nice introduction of organic matter through leaf fall, things like that, that help support those aquatic ecosystems.
Yeah.
So when we're looking at things like our fish biological diversity and our insect macroinvertebrate biological diversity, we certainly look at habitat as well. And when we think about water management big picture, all those different programs come together to say, okay, when we're looking at how to protect this creek, tree canopy also makes a difference.
Okay. Thank you.
Thank you, and thank you for your presentation. And to give a little bit broader overview of the conversation, the Metropolitan Water District, I call it the Monumna District because it had so many letters to it, but the Metro District by law has to do certain things, and it's funded because of that. And in the beginning, the crisis was the rural parts of our state, which is very numerous, several counties versus very few counties. But there was no dialogue or exchange. But through the years, there has been a concerted effort on the part of the Metropolitan Water Planning District to be a resource as well as to partner and look at the issues. And that takes place through our regional water planning districts. And I want to point out to anyone listening that you are now forewarned that, so get engaged in your regional water planning districts. That's where the input comes from. So at times, when times are not bad, it's kind of a dormant resource, but when times are very difficult, it's very important. So we need to do that. And I hope that we never have to go through a drought again. But when we do, it is unbelievable. And I'll end this by a story. My grandson was 3 years old. We couldn't water our grass because we were limited to our water resources. This is in Coweta County. And he had a little friend over, and the friend wanted to go play in the basement where all the toys were. And my grandson said, no, we can't. That's where the drought lives. So it actually, it actually had such a personality and impact that the little ones were processing it as an evil dude. And so it is. And we need to do everything we can to be good stewards of what we have. And I just want to do a shout out to our presenters because we do have our emphasis in this state on the right directions, but you have to have controversy, and from controversy sometimes comes really positive results. And usually those answers aren't simple. So thank you again, Anya, for your presentation. And up next, so I'm doing all my notes all over the place. I think we're going to hear from Scott Robinson, DNR. And are you locked and loaded for your presentation?
I think so. I think
Okay.
we're ready here. Thank you, Madam Chair. Thank you for the time. I really appreciate the opportunity to speak to this committee. You're going to see something similar to what I talked about to the committee last year, so some of you have seen this before, but I think it's still relevant. I cannot promise to maintain the level of quality of presentation that you've seen so far, but I'll do my best. So I have the honor of serving as the chief of the fisheries management section in DNR. We manage fisheries and fishing access all around the state. We have 10 fish hatcheries and stock fish and invest in fisheries management all over Georgia. Fishing, let's see. I'll turn this thing on you. There we go. All right, so fishing is very important to us as a state. It's very important economically and socially. We've got some updated numbers from recent surveys that show it accounts for over $5 billion worth of economic activity each year in Georgia. It's responsible for over 15,000 jobs, and there are over 1.6 million licensed anglers in Georgia. So chances are either you or somebody you love loves to fish. if you're in Georgia. So, and again, a lot of jobs, a lot of economic activity. It's part of who we are. We have the largest plastic lure manufacturer in the country in our state, and Zoom Worm Company in Watkinsville. We have Yamaha Motor Corporation, one of the largest manufacturers of outboard motors, is housed here in Georgia. And literally hundreds of companies from small to as big as Yamaha and Zoom that serve the fishing industry and anglers in Georgia. It's also really a part of our culture. We have iconic fisheries like the Satilla River redbreast fishery. We have the shoal bass. We have most of the shoal bass that exist in the world live here in Georgia. We have the southernmost trout populations in the United States here in Georgia. So we have a lot of iconic and important fisheries that bring people to Georgia to enjoy that fishing. We have, for nearly 100 years, we've held the world record for the largemouth bass, the largest largemouth bass caught in the world. It's one of the most pursued sport fish records in the world, and we've held it for nearly 100 years. So fishing is important to our state, and we are important to the sport fishing industry. So what does my team do, the WRD Fisheries Management? We, again, help facilitate and manage all this. We set fishing regulations. We operate 10 fish hatcheries and stock over 8 million fish each year. About 1 million of those each year are catchable sized trout in the North Georgia mountains. We maintain between WRD and the Coastal Resources Division over 200 boating access sites. And we have a crew that works year-round on boating access, improving those sites and building new sites and maintaining existing sites. These are important economically for rural communities as well as communities like Lake Lanier. So a lot of that. We survey and monitor fish populations. So we keep tabs on fish populations. How are they doing? How are these fish populations doing? What are things that impact them? And then how do we need to regulate those to make sure they're protected both now and for future generations? And then we also do a lot of educational efforts where we teach people about fish and the outdoors and how to fish and how to safely and ethically enjoy those wonderful natural resources that we have. Fishing and hunting are so important to Georgia that they're enshrined in our state constitution. Protection of those rights to fish and hunt are covered in our state constitution. Like water, the state has the ownership of all wildlife. So we manage wildlife and we regulate its use for the public good. Very, very similar to the way we manage water. We manage wildlife. Wildlife resources are managed in accordance with sound principles of wildlife management and scientific tools, and that management includes hunting, fishing, and the taking of wildlife. So you've seen this already. I won't spend a lot of time on this, the definition of navigability, the legal definition, and the rights of the owners of lands adjacent to navigable streams extend to the low water mark in the bed of the stream, and the state owns the bed of a navigable stream or river. You've also heard from the previous speaker about a lot of the different navigability definitions. So these are some of the things that we use in DNR. We have to practically make determinations. Is this a navigable stream or not? Just to do our jobs properly. Where would we put boating access? Where would we stock fish? Where would we invest public funds where there is public access available? So we use all of these different factors to try to determine where a navigable river or stream might exist, again, so that we can invest license fees and federal funds, excise taxes on fishing equipment to establish fisheries, to build boat ramps, to provide access to anglers, and to make sure that fishing is available and accessible to Georgians. Again, a lot of different factors go into that. We've really had no choice a lot of times but to determine what might be navigable. So we've looked at all these different things, current state and federal law, court cases, attorney general opinions, historical documents, and stream characteristics to come to some of these determinations. We certainly have not determined that for all streams in Georgia. And I want to make one point here. As we went through the study committee last year, there was a lot of implications that DNR, or my team in particular, was trying to expand the definition of navigability or somehow change it, and that's not the case at all. That was never any intention of ours to do that. We were reacting to circumstances that appeared to be cutting into public access that had been historically established since before we were even state. So no intention on our part to expand the definition of navigability. So we did, working with Representative Burchett, we developed some lists, things that we've used in the past, some maps. We looked at streams with 400 CFS mean annual flow and developed these maps that we consider the very floor, the baseline of what might be considered navigable streams in Georgia. Again, there are many more that would be navigable. We think these are beyond debate, and you can see the map there. That one shows North Georgia and then South Georgia, major rivers where we've put boat ramps and invested public funds for decades to allow public access. And people have been allowed to use these rivers and streams accordingly since we've become a state. And so with that, I'll wrap it up and be glad to take any questions.
Thank you very much for your presentation. One of the points I want to make here is that to enforce where you can fish and not fish the disputes, our DNR rangers go out, and usually it's solo. Usually it's large areas where there's not a resource or a way to get additional help. And that's just one factor, and one of the driving points is to how do we come up with some type of certainty. But it's also important for our landowners, our citizens, and the visitors to our state. I want to mention that this body, a few years ago, created the Georgia Outdoor Stewardship Act, and the funds from that go to the management of our natural resources, which includes land purchase and such as that. So there is a commitment in our state to protect our resources. And again, Georgia has got it right, but we do need to hear from you, and there'll be several more questions as how do we help as we go along with this. And so to my committee, anybody who has a question, now would be the time to ask. Okay. Number 18.
Thank you, Madam Chair. Appreciate the presentation. I was able to hear you present a couple times last year.
Yes, sir.
Done a good job. The 168 boat ramps that the wildlife resources have built, that's on rivers, lakes. That's all of those.
Yes, sir, both. And a lot of ours are built on rivers because many times the controlling authorities, whether it be Georgia Power, Corps of Engineers, will build ramps, boating access sites on the reservoirs, the large reservoirs. But in cases where it's appropriate, we've done those as well.
And would it be true to say that where those ramps are built in a river, from that point downstream is open to the public?
Yes, sir.
Am I right on that?
That's certainly the way we look at it.
Okay.
Yep. We wouldn't build one if we didn't think
Right.
it was open to the public. Yep.
And the other 42 sites, what is that, the additional 42?
That's the Coastal Resources Division, so those are
Okay.
typically saltwater access.
Awesome.
Which won't surprise you, it's another code section. So thank you. Number 22.
Thank you. Always good to see you, sir.
Yes, sir.
It's always a great revelation, and you made the statement that the state owns fish, the birds, all the wildlife. I'm lecturing to a class at a church not too long from now. And it's going to be a great revelation for them to know who really owns the wildlife and the fish. I will say that at the end of my presentation, right before I leave.
Okay.
To help you out with that, legislators are not considered wildlife, right? All right, number 18.
Another question. So on the, you're talking about the U.S. Corps of Engineers, the list of navigable, non-tidal waters, major navigable rivers, and then the 400 feet per cubic
400 cubic feet per second.
per second. Are all of those listed on there? Are those 400 feet or higher, cubic feet per second or higher?
Yes, sir. All those on the map there.
Yeah.
That's basically what we use to develop that map, along with these other factors. But yeah, all of those that are shown on the map are 400 cubic feet per second mean annual flow.
In order to have 400 cubic feet per second, how wide would a creek need to be? Is that
It can.
is that a loaded question?
Yeah, well, not really. I mean, it can vary tremendously, though, depending on the depth. You know, so typically we look at things that are a minimum of 30 feet wide.
Okay.
Thank you. Very quickly, I see no more questions. Thank you very much for your presentation, and obviously stay tuned.
Thank you.
For our committee, this is just our toe in the water, so to speak. We're going to be looking at several different aspects of this, and it will take us a while to set up some of our meetings because of where we think we need to be in the hotel. So we're going to be working on it all fall. But our next meeting will be on September the 20th, and it'll be at Unicoi. And one of the reasons for there is they have both navigable and non-navigable areas for us to look at. So we will have announcements and information to go out. I have another question real quick, number 22.
Just a quick question. I was going across this very interesting map, and tell me why the big Statilla Creek at only 3.1 miles is called big.
I will answer. That's called a puzzlement. Okay. So for the committee, we will stay adjourned. I ask the committee members and the presenters if you'll come up to me briefly. I have to get one more bit of information from you. Thank you. To those listening, my thanks. And yes, stay tuned. Thank you.